I do have skills that make me a nightmare for people like you.
Just a little word of warning to everybody out there, by the way. Going around on Facebook at the moment, apparently fake ticket issuers or some scam artists out there are issuing what looks to be fake parking tickets or infringement tickets, and they're putting them on the middle of the rear window wiper of the car, so when people notice them, they get out after getting in the car and putting the key in the ignition. They get out, go around the back looking in the rear vision mirror, get the ticket out, they swoop in and steal the car. So beware of that out there, people. If you see a ticket in your rear window wiper, drive down the road first before you get out and take it out of the wiper blade. Just a friendly bit of advice. Rightio, part 15. Boy, we're getting up there. This is basically the correspondence between myself and Vanessa, the parking prosecutor, who seems hell-bent on going through with an unlawful prosecution, and also Philippa, the court services manager on the criminal division, in regards to recording and being given some evidence or some information as to who the mystery judge was that's declined it and all the rest that goes on with it. And there is some interesting information to find out very shortly. An old blast from the past is going to be around tomorrow. It's the 24th today, so court's tomorrow. Okay, so first off we'll start with the letter from Vanessa. This is the response I got from her in relation to the letter I sent to her on the 10th of December, and she wasn't there and has taken a month to respond. Okay, so 9th of January from Vanessa. Dear Sir, calling me sir is kind of like putting an elevator in an outhouse. It just don't belong, but okay. Auckland Transport, me be them. In response to your email dated the 10th of December 2018 follows: 1. Auckland Transport is an enforcement authority, and AT's functions and authority are prescribed in, amongst others, Section 45 and Section 46 of the Local Government Auckland Council Act 2009. The parking warden issued the infringement notice lawfully. I'll repeat that. The parking warden issued the infringement notice lawfully. No, he didn't. And as earlier advised, your demand for payment is declined. What a parking prosecutor in relation to an alleged offence has to do with my administration fee being paid, just can't fathom it myself, but she seems to think she's got some sort of say in regards to whether or not my invoices are valid. She doesn't. That's why they have things called judges. Number 2. No witness statements are taken, and the officer's notes made at the time were included in the disclosure pack of 19 November 2018. 3. Auckland Transport does not prepare briefs of evidence for minor traffic matters. So it's just minor to them. If it's that minor, why spend thousands of dollars attempting to get a conviction for something that should never have been issued in the first place, because your policies state you shouldn't be issuing them? But we'll carry on. 4. I can confirm that parking warden number 1126's full name is Stephen, last name withheld, not Steve. Because if they're going to call a witness, then make sure they get their name right, eh? Because there can easily be two people with very similar names. And you don't want to get the facts straight, don't you, Vanessa? 5. Auckland Transport anticipates calling only parking warden, last name withheld, as a witness. 6. Officer, last name withheld, issued the infringement notice and took the photographs on the 12th of October 2018 and 15th of November 2018, and they are relevant to the offence. 7. The parking warden who issued the infringement notice's criminal history, if any, is not relevant to the offence, and the information is withheld pursuant to section 14.2a of the Criminal Disclosure Act. In other words, she's deeming it not relevant. And yet I've requested his criminal history due to the credibility of him. I think credibility is an issue in this regard, and criminal history does go a lot to credibility, I would think. But she's deeming it irrelevant, so we'll see what the judge or JP, my old friend, has to say tomorrow. 8. As earlier advised, the details of the charge filed with the court are contained in the notice of hearing. So that's her response again to explaining to me the nature and cause of these proceedings. 9. Your question on how the decision is made, who to issue the infringement notice to, 7, and your request for the details of the administration staff member who signed the letter dated 3rd of November, the mystery adjudicator, are being treated as Official Information Act requests under the Local Government Official Information and Meetings Act 1987. You will receive a response from Customer Liaison Team in due course. And that file number is CAS 948937 Q6R5C4. Got an acknowledgement of receipt for that Official Information Act from Auckland Council. Yours faithfully, Vanessa Olivia, the lady who likes to hang up on people. My response to Vanessa 10 days later on the 19th of January are as follows. And I CC'd this to Waitakere District Court, so always keep the registry in the loop. And I also CC'd it to John Smallbridge. Now I got the last name wrong, his last name is actually Strawbridge, and I have corrected that and sent it through after the fact.
What happens when you're falsely accused and the authorities won't listen?
Paul Martin took the T3 lane and wound up in another jam.
And just trying to get somebody to listen to me.
He's facing a hefty fine.
If I was liable for it, I'd just pay it.
It's $170, but it's also a principle at stake.
I don't want to pay it because I'm not liable for it. I've had there's 3 people in the vehicle. Do they not include children as people?
From the roadside, it looks like Paul all alone, which is why the guy from Auckland Transport clocked him. When the fine arrived, Paul thought a phone call to Auckland Transport would fix it. More calls followed. He sent back their photos with his explanation. Then Paul offered to go to court to explain himself, but somehow Auckland Transport skipped that step.
But at the end of the day, they just keep sending you reminder notices. And it wasn't until I started getting them from Baycorp threatening that I thought, oh, what's going on here?
Paul put Baycorp straight, and Auckland Transport flipped it to the Ministry of Justice for enforcement proceedings.
You haven't been able to show that I don't have 3 people in the vehicle, and just really want somebody to have a look at it and come back to me.
Auckland Transport turned down his appeal, telling Paul he should have asked to go to court sooner, which he had, but that hadn't happened.
You don't seem to get a chance to actually go forward and explain what's happened.
The main driver, of course, for all of this is to lower congestion on our network and for the T3, T2 lanes and bus lanes to be used as they're designed to be used.
This is John. He runs the part of Auckland Transport that controls who gets fined and how.
Does the driver have to prove that there were 3 people in the car?
We have to prove that they didn't have 3 people in the car.
Which for Paul is good news, because
The ticket has been waived. We re-reviewed the footage. I've had a look at it as well. He absolutely, resolutely says his children were in the car. We accept his word. And the infringement's been waived.
he admits there was also an issue with how Auckland Transport dealt with Paul's request to go to court. Which of course won't be necessary now.
Good result, good barbecuing, and well done to Auckland Transport for fronting up.
This road here in particular, 70% of the people that travel down this road are using mass transit, so they're using either public transport or they're carpooling.
In November, they trialled more enforcement officers.
And we close to doubled the number of people that were infringing.
1 month, 743 fines. That's more than $100,000, but already it's back to being a backlog. But if fines don't work, how do you keep Auckland moving?
Sorry. But yeah, to John Strawbridge, who is supposedly, according to There You Go, Auckland Transport's head honcho of the parking. Dear Vanessa, Auckland Transport v us. We thank you for your correspondence dated 9 January 2019, which we received via standard post on the 15th of January 2019. As in previous correspondence, we shall respond to your correspondence dated 9th January 2019 point by point. 1. Thank you for informing us of the legislation surrounding the powers and enforcement authority of AT. It would appear you are in error, as we have provided ample evidence prior to now showing that the infringement Stephen issued that day was in fact unlawful. For example, on pages 64 and 65 of the Parking Compliance Training Manual that we have already supplied you, it clearly states, page 64, traffic control devices, markings on road surface treatment. Okay, so road markings are considered traffic control devices. Page 65, traffic control devices must not dazzle, distract or mislead road users and convey a clear and consistent message to road users and be maintained in good repair. All of which the location opposite Harvey Norman's on Ratanui Street, where Stephen unlawfully issued the infringement, did not satisfy. Although the photographs taken by Stephen on the 15th of November do not show a vehicle, or like the photographs from the 12th of October 2018 show no offence being committed, and are therefore irrelevant in that regard, they do show conflicting road markings, as do the numerous photographs we have also supplied to yourself have indicated. Furthermore, between the 14th and 16th of January 2019, after Auckland Transport being formally notified by myself on the 4th of December 2018 of these faulty road markings, the misleading and unclear markings have been corrected. Yay! And road users will no longer be misled. CAS 940216C5D8J4 for your reference. We will, however, be making further Official Information Act requests as to how many P107 infringements had been unlawfully issued within the last 4 to 6 months, and requiring that AT refund all road users who were clearly issued these infringements in error. As stated previously, we are aware of at least 2 infringements being issued 15 days after AT being formally notified on the 4th of December 2018 of these faulty markings. Unacceptable. As you are acting as the prosecutor assigned to the alleged infringement, and not, as far as we are aware, anything to do with AT's accounts payable department, we again point out that your opinion as to the outstanding sum that is now almost 3 months overdue, is of no relevance. Our administration fee for processing AT's unlawful issued infringement and Stephen's tacit agreement he has formed in doing so is not for you to decide the relevance of, nor is it for you to decline. Hopefully that is crystal clear, Vanessa. 2. If there is no witness statement taken, then the report details will suffice. As the factual inaccuracies within Stephen's report details for this matter are evident, enough of his lack of credibility. For example, visual check, yes. Did he not notice the road markings? Sign road markings, good, yes. That was false, due to AT correcting them. Ticket printed, yes. No ticket was placed on the car that day, and driver returned, yes. If so, why not use Land Transport Act Section 128E to ID the driver? They have that power under Section 128E to identify the driver, or the person they suspect of committing the offence. And because they're investigating an alleged offence, they do have that power. They can't just come up and ask anybody for their details. They have to be witness to an offence and then require those details to create the infringement. Define driver. As to our knowledge, no man or woman that day was operating a vehicle transporting goods or passengers for reward or hire. What driver? And yes, Vanessa, that information was supplied in the disclosure pack, unlike any witness list, which you had failed to supply until we asked for it. 3. If Auckland Transport considers a Category 1 criminal offence with a maximum penalty of $1,000 to be a minor traffic matter, so be it. We consider perjury, see sections 108 and 109 of the Crimes Act 1961, unlawfully issuing of infringements, breaching your own codes and procedures, and conspiring to prosecute a person knowing the alleged allegation itself is an error, see section 115 of the Crimes Act 1961, to be far more serious, as should yourself, Vanessa. And then I supply her the Crimes Act, cut and paste straight out of legislation. The Crimes Act section 108, perjury defined. Crimes Act section 1961 section 109, punishment for perjury, and I would say subsection 1 applies in that regard. 2, you know, it's not for a penalty or a criminal offence, so section 2 doesn't apply, but certainly lying on the stand does. Should Steve go ahead and try doing that. Crimes Act 1961 section 115, conspiring to bring false accusation. Well, clearly there's 2 or more people that are well aware of this allegation being false, because I've supplied enough factual evidence and by their own actions repairing the fault. That should suffice that the allegation was made in error to begin with. It should never have become an offence or been filed in a court. And not take that to note, people. An offence is only created once a charging document is filed. Before you get a court summons and before any hearing is set, there is no offence. That is created when the provisions are filed on a charging document. Prior to that point, it's just an alleged infringement. It is a notice. It's that simple. And they want to skip the entire process, and then they'll try and go to Bay Court to enforce a parking offence that never existed because it never was in court. 4. Thank you for confirming that Warden 1126's first name is Stephen and not Steve, as that matches the warrant of appointment as a parking warden issued to Stephen, last name withheld, which is publicly available information from the Notice of Council minute dated 14th of July 2003 on page 13. No Steve, last name redacted, is listed. So what does that tell you? 5. We too eagerly anticipate cross-examining your sole witness as to ascertain the truth, whole truth, and nothing but the truth, though, judging by Stephen's report details in relation to this allegation, you may wish to inform him of sections 108 and 109 of the Crimes Act, should he maintain the road markings were okay, yes. 6. Thank you for informing us of who the officer was that took the irrelevant photographs you supplied in your disclosure from the 15th of November 2018. Although they are irrelevant to the alleged infringement, given they do not show a registration plate or a vehicle of an offence being committed, see page 126 of your AT Parking Compliance Training Manual already supplied, However, they do show misleading road markings and confirm no infringement should have been issued given that fact, and that Stephen has made a false entry on the report details. 7. Although you may think you get to decide what is relevant or not, as our request for your witness's criminal history is directly in relation to his credibility given the above mentioned false reporting, we consider his criminal history extremely relevant and shall be happy to let the judicial officer presiding over this matter on the 25th of January 2019 deem the relevance, and not yourself. Stating pursuant to section 14.2a of the Criminal Disclosure Act, that this information is withheld, or in layman's terms, you're deeming it irrelevant, please inform us as to what you deem to be relevant, if not your sole witness's credibility, given his false reporting. Vanessa, you may wish to refer to section 115 of the Crimes Act 1961 yourself also. 8. So the cause and nature of your allegation is written in legislature, which is a language used in court, not standard conversing. We comprehend you alleging that the alleged parked on broken yellow lines. Best be ready to define the words used in that legislation for us and translate them to an English interpretation, as we wish to be fully and fairly informed in common English terms, as we are not legally trained to correctly interpret the language used in courts. However, we do know the rules of the game better than most. Ipse scientista poeste est. In other words, knowledge is itself power. 9. We have received confirmation and reference CAS 948937 Q6 R5C4 in response to your OIA request made to ascertain how AT chooses which registered owner to issue the alleged infringement against, given in your case there are 2 options, or 2 possibilities, and who signed the adjudication decision letter dated the 3rd of November 2018. Thanks for that. In conclusion, we look forward to seeing you in court, as it will be more difficult to avoid our questions than hanging up on us when we called you early November. We shall enjoy seeking opinions and information from yourself and Stephen in the months to come, should you see fit to waste public money on a clearly unlawful prosecution. Given the facts presented by us to date, we are certain, should a judicial officer remain honourable, impartial and independent, that justice will prevail. All wrongdoers in relation to this unfounded allegation will be held accountable. Notice, consistent with rights affirmed under New Zealand Bill of Rights Act 1990 Section 14, all correspondence shall be published on multiple forums for maximum accountability and transparency of public servants and services in the interest of fair and open justice. Me. That was the letter that I responded back to her trollop. But at least she's put in writing that she's claiming that ticket to be lawfully issued. And we all know, including people that happen to work for Auckland Transport that I speak to, that agree it should never have been issued. We all know it shouldn't have happened. So it's sad that they can't pull their finger out of their rear end and admit that our bad, sorry. You know? A payment in good faith for the fucking around Auckland Transport, of course, me, just as they did with Paul Martin in the T3 terror story that Fair Go published. You know, they should compensate people when they do something wrong. They expect us to compensate them whenever they allege something that we've done wrong. So, don't things go in swings and roundabouts? To finish off, I responded to Philippa. And I will just get that for you now.